Welcome, everyone. My name is Lisa Gora, and I'm a shareholder with the law firm of Wilentz Goldman Spitzer. I'm located in Woodbridge, New Jersey, and I am a corporate healthcare and now cannabis attorney. So I represent healthcare clients from medical practices to individual physicians, licensed facilities in New Jersey, hospitals, and now that practice has now dovetailed into also the cannabis practice. So welcome everyone again to AHLA's first podcast to discuss the cannabis industry and the somewhat recent phenomenon of cannabis law. Only in the past few years have legal scholars began to think of cannabis law as an independent field of law worthy of study in its own right. Previously, when people thought of cannabis law, they would tend to think of criminal laws regulating the use, possession, and distribution of cannabis. And those laws certainly raise a number of important and interesting issues. However, there's actually much more to cannabis law than just those criminal issues. In fact, cannabis law is one of the more far-reaching of legal topics today because it necessarily implicates a number of different areas of law. And that is why we're here today, to discuss how cannabis law is a multidisciplinary area that implicates not only business law, not only healthcare law, but it also implicates real estate law, intellectual property, tax law, banking, investment and securities, mergers and acquisitions, and healthcare law again. And here with me today are two of my cannabis attorney colleagues who both specialize in cannabis as well as other areas of law. So if I can have both Richard Cheng and Alexander Malyshev introduce themselves, their areas of practice and where you're located.
Sure, Lisa, I'll go first. My name is Richard Cheng. I am in Dallas, Texas. I got into the cannabis industry about 8 years ago in late 2013. Historically, like you, Lisa, I've always been a healthcare regulatory and corporate attorney representing a myriad of different types of healthcare providers and private equity and private investors in everything from skilled nursing facilities, home health, hospice, MSOs, retail medicine. And about, I would say, again, 8 years ago, had a very fortuitous moment where the firm said, hey, you're one of those weird healthcare guys. Maybe you can help us figure this out. The client wants to know the legal liabilities for a physician prescribing versus recommending medicinal cannabis. And keep in mind, this is 2013, and I'm also in Texas, right? And so I fell into it and obviously found it very intriguing and have, as they say, the rest is history. Later on, joined a AmLaw 200 firm, which at the time had one of the few national cannabis practices in the country. And then from there, had a very good partner that said, hey, listen, I'm so busy with this, with licensing in my home state, you're really going to have to take on everything else. So it compelled me and gave me an opportunity to really grow and cut my teeth on a variety of different things. And then subsequently to that, I joined a big global firm and launched the hemp practice group there. And of course, now I'm at an all healthcare and cannabis boutique and represent everything from physicians to labs to cultivators all the way down to retail and everything in between along the supply chain. And lastly, I teach cannabis law as an adjunct at UNT Law School.
Great, very, very highly skilled, qualified speakers we have today. So then I'll pass it over to Alex to introduce yourself.
Yeah, hi, my name is Alex Malashev. I'm a partner at Ledyard in New York. I am a litigator and regulatory lawyer by trade. As with everyone else, nobody started as a cannabis lawyer. New York has traditionally been the place where companies came to fundraise. While we have had a medical cannabis law on the books for about 7 or 8 years, it's actually has been very limited. There were only about 5 vertically integrated medical cannabis providers initially. That extended to 10. That is not the law anymore. We had a very big amendment earlier this year in April. Yesterday, we finally got our last board member approved to our regulatory board. So we are going to launch, and it's going to be very different from what we've had. So we're going into the adopting the alcohol model for cannabis, which is going to be decentralized for adult use. Right now, we're dealing with people who actually want to participate and apply. That has certainly not been traditionally what we've done in New York. Again, we come from fundraising. A lot of Canadian companies that used to come to the United States do roll-ups, IP kind of work, and also a lot of hemp work. We are now transitioning to actual cannabis licenses and operations in New York, which will be very interesting.
Great. Well, thank you for that introduction. And just for the sake of the audience, I'd like to highlight that, Richard, again, is from Texas. Here we have Alex, who's from New York, but practices in the New York and New Jersey space. I am from New Jersey. I focus on the cannabis and healthcare practices in New Jersey. And then Richard is from Texas, but also practices in Oklahoma. So what the importance is with that is that we now understand that there is this cannabis industry, but yet this patchwork of different laws and different processes within each state. So as attorneys, we all understand that we have the federal regime that we have sometimes to emphasize for our clients, especially in the healthcare space when you're dealing with hospitals and other licensed facilities who are receiving Medicare and Medicaid. So first and foremost, you look at the federal overlay, the federal laws, then you look at the state laws. Each of us are practicing in different states. And so you have to be in tune with the laws of that state. But then also with regards to maybe local laws that each state has. So with that in mind, as you heard, Richard, who practices in Texas and then does work in Oklahoma, I have a few questions that I would like to ask them. But before we get into that, I just want to highlight that presently, given the patchwork of different laws in the United States, 36 states have approved medicinal cannabis programs and 19 states have approved recreational programs. So with that in mind, Richard, what is the current status of the legal cannabis market in Texas with regards to medical? Does it have medical? Does it also have recreational? And you could also shed some light on Oklahoma.
Sure, not a problem, Lisa. In Texas, the recreational it does not exist. It has not been talked about very much. I think Texas is going to be one of the last states that really approach the recreational play in the cannabis industry. But to many people's surprise, in Texas, Senate Bill 339 passed on June 1st, 2015. So in reality, Texas has had a medical marijuana program for 6 years now. It started off with one qualifying condition, and that being intractable epilepsy. It didn't really grow in 2017, 2019, and of course in Texas, the Congress meets every other year on odd years. In 2019, they expanded it to 7 different qualifying conditions, one of which has I believe it's like neurological degenerative diseases, which has like 30 different categories. That sounds like a lot, but it's really not. It's still very limited, and the amount of THC that's available in the products is at the time it's always been 0.5%, and just most recently it raised to 1%. In the 2021 session, it actually we added a condition called PTSD, and of course, PTSD is pretty broad in how you define it. And what we're seeing is that typically we've looked at between 500 to 700 enrollees into the program. And for the longest time, it hovered around 2,000 to 3,000 patients. This month alone, because of PTSD that was activated September 1st, it's estimated to be about 1,200, and it's predicted to be about a 30% growth rate between now and May. But that's really the legal status in Texas. The Department of Public Safety oversees it. There's only 3 licensees in the state of Texas at this moment.
And all medicinal ATCs.
It's all medicinal. Yeah, it's all medicinal, and it's vertically integrated, which allows the licensees to cultivate, to process, and to retail. And typically in Texas, really 2 of the 3 licensees are active. One of the 3 is not even active. They'll set up drop-off sites, and sometimes it can be at nonprofit organizations, or many times it's at physician offices. So the physicians, they themselves do not actually dispense. What they do is they see the patient. If the patient can qualify for the Texas Compassionate Use Program. It's what's called, or TCUP. They go into the system, they register them into a system what's called the CURT system, and they become a patient. And of course, whenever they pick up the tincture or the lozenge or whatever product they're picking up, based off of the prescription that the physicians actually provide. And I do want to emphasize the word prescription, even though there is a nuance. And the reason I say that is because under the Texas Occupations Code 169, it does actually use the word prescription over and over again. So that's the landscape of the Texas medical marijuana program. A lot of the cannabis activity here is centered around hemp, and of course the wellness products. Delta 8 is obviously a topic that's talked about here, and people are getting in on that. So I would say that it's anticipated that the medical marijuana program will increase, but there's also a lot of political, we'll just say some political turmoil in the sense that obviously the 3 licensees have been granted these 3 licenses, which are very expensive, and they've invested a lot of money. So there is some pushback with the current licensees, say, hey, DPS, Governor Abbott, do not issue any more licenses. We got to get our money back and make our money back before you issue any more additional licenses. And of course, other states are interested in Texas because it's a big state, has a lot of people, and there's potential there.
Very interesting. Well, I think it's worthy to note that then Texas, at least compared to the states that we'll be talking about today, is certainly more limited than at least New York and New Jersey. And New York and New Jersey still are in their infancy stages as well. So to juxtapose that, which Richard just provided us with the landscape of Texas, let's hear about New York. So Alex, go ahead.
Sure, thanks, Lisa. And it's very interesting to hear what Richard said about the 3 existing licensees trying to pull up the ladder behind him, because that's actually what happened with our initial 5 licensees about at this point 3 or 4 years ago, when they fought tooth and nail to make sure the other 5 licenses were not issued. They ultimately lost. They actually filed a lawsuit trying to stop the regulator from issuing the extra licenses. And the argument was very much the same as, we're not making any money. Why are you going to issue more? I think as of the beginning of this year, we had about 200,000 registered patients in the system, a little north of that, which while certainly a lot, probably more than what's in Texas, it's a very small percentage of our population. My unofficial survey says there are a lot more than 200,000 pot smokers in the state of New York. So
I would agree with you on that.
Right. And that actually had, they phased out a lot of the restrictions and, criminal possession thresholds in earlier rounds of trying to amend the statute. But in April, we finally had an amendment that actually is phasing out. The current program is transitioning into an all-new board. So we had a comprehensive overhaul bill that now allows us to have, in parallel, a adult use, which is going to be a big market, and a medical. The medical providers have actually been allowed to keep their integrated licenses. Much like Texas, those are very expensive, and they would be paying a lot to transition them. They'll be allowed to open up a few co-located adult use dispensaries. But the plan for New York, at least, is to have a lot of decentralized licenses, especially at the retail level. And that is also part of New York's push for social equity. So they are trying to reverse some of the consequences of the war on drugs. There's a preference for people who have been impacted by the war on drugs on actually getting some of those retail licenses. It remains to be seen how it's implemented. A lot of my work centers are sort of on the fundraising portion. And as you probably know, banking remains a big issue. So while the states are doing their best to maybe minimize the application costs for some people, making it easier to get those either in New York, they're called social equity licenses. In New Jersey, they went with a provisional licenses and something that allows people to get their foot in the door. But there's a lot of problems with the actual operation because as you sort of indicated, there's a lot of tentacles here, and I tend to think of cannabis as an industry as opposed to a practice area. And there's a lot of issues and a lot of legal issues. One of the big ones is the tax. You can't, whether adult use or medical, you cannot take a lot of ordinary business deductions because of the IRS rules that have to do with the fact that cannabis remains federally illegal. In fact, a lot of states replicate that at the state level as well. And that's something that people who actually want to participate in the industry have to understand. So it's still expensive. We're still trying to think through how to allow people who are not super well capitalized to actually get their foot into the door. As you might know, investment usually doesn't really come until you have a license, and it's an expensive process to get to that. There's also some limits on the ownership structures that social equity applicants can engage in, how much control they can see. So it remains to be seen how they actually work that out to actually, on the one hand, make it profitable enough for them to stay in business, because there's actually a limit on the number of licenses, and you can't a lot of times do cross ownership across the 3 tiers. So work in progress. As I said, we just got our last person appointed to the board. That means the rule writing process is going to start this year, hopefully, which means maybe we'll get some licenses next year. Yep. But the ATCs currently, which is our alternative care centers, the
alternative treatment centers,
they're called in New Jersey, right? In New Jersey and in New York, they're just called medical providers. They have a window now to actually get a jump on. They'll probably be able to start dispensing recreational before anyone else, because the license is only the first step,
right?
And then you have to.
That's very similar to New Jersey. And I think out of the states that have already been mentioned, I'm at least happy to know I'm from New Jersey, and we're at least the most progressive state out of the states being mentioned. Not anywhere near to California and Colorado, but we're certainly now past a little further than New York, where we have a medicinal market, the medicinal program, where we have about 15 locations for our alternative treatment centers. And then we do have adult use, and we've at least sat everybody on our Cannabis Regulatory Commission, the board that regulates adult use, and as well have issued our rules and regulations. So we hopefully will be seeing adult use sales, sometime in the first of 2022. So certainly within the latter portion of that year. And it will be the medical alternative treatment centers that will be able to do that. But just tying back a few things that everyone's already mentioned, I think it's very important for at least terms of this podcast to outline, I like the word tentacles. I liked, that each person is outlined that there's obstacles and certain implications that anyone getting involved in this space, whether it's non-healthcare related, whether it is someone such as a physician or a hospital or other licensed facility that wants to get involved in this space, there are those various tentacles you have to keep in mind. And one of the things that Alex brought up was tax issues. And that all goes to the federal regime, the federal law. So what I like to talk about is, despite the legal frameworks created in each state, as we've heard about now, regarding the regulation of cannabis activities, cannabis remains illegal at the federal level. So i.e. it's illegal to possess, manufacture, distribute cannabis, because in the eyes of the federal government and pursuant to the Federal Controlled Substances Act, cannabis is a Schedule I drug, and therefore there's implications for anyone that is looking to get involved in this space from the federal overlay of the federal laws. So with that in mind, Richard, even as states have legalized the use, sale, cultivation of medicinal cannabis, does that mean a physician can dispense cannabis for medical use? And this is something that you touched on earlier.
Yeah, Lisa, I mean, I think to your point, I think as a whole, you have to look at you have to consider the fact that it is a Schedule I drug, and most physicians, not all, they are under various payer contracts. Many physicians have a DEA registration card. Typically physicians, they don't really dispense per se. That's been my experience. Of course, you have to look at the word dispense and how it's defined under state law. It could be very different from state to state. I would, if I were to represent a physician, a couple of things I would look at is I would look to see if the state medical board takes any position on what they can and can't do. I would consider the fact that if a physician is taking payer sources from a federal healthcare program, that is a consideration. Now, granted, on the federal level, CMS has never expressly come out with with any particular guidance or any particular position on it. However, if you look at the fine print with every Medicaid contract, with any Medicare certification, you do agree that you are going to comply and adhere to not violate federal law. And by dispensing and providing, a Schedule I substance, that does put you at risk, in my opinion. Now, granted, there hasn't been any enforcement actions that I know of on physicians that's done that, but I think you really do have to look at a couple things before you just jump into say, hey, a physician can or can't dispense. Those are all considerations. I think similarly to healthcare law, it's never a black and white answer. Can you or can you? It's different. It's a variations of shades of gray. And there's higher risk, there's lower risk. And there's also some federal considerations too, like the Roy Walker Farr Amendment, which I think now is called the Blumenauer-McClintock Amendment now, which that federal source of protection does apply to medical marijuana programs on a state level. And it's been supported in the McIntosh case in 2016 in Ninth Circuit that says that if there's strict compliance with state medical marijuana programs, that the Department of Justice is prohibited from allocating funds for the purposes of prosecution. So that's something to consider. There's also some other good case law, like there's a Walters case that actually talks about physicians who recommend medical marijuana as opposed to prescribing medical marijuana. That in itself is a source of protection that prohibits the DEA from withdrawing the DEA registration. Hence the reason why the recommendation versus the prescription is a sensitive topic with physicians. So that's my position on it.
Yeah, and I agree with you. I mean, I have those same concerns. Again, it goes back to, and I want to emphasize what you said, is that it's just a risk tolerance game at this point, is that there's considerations that as attorneys, we need to provide to our clients that are in the healthcare space. And depending upon their risk tolerance, we provide them the information with regards to these guidances, protections that may be available under federal law. However, there's been no enforcement activity taken by any of the federal agencies right now against healthcare entities. But we never know if it will come tomorrow or in a few years. So that's something that, again, the client has to consider. So then even with that in mind, turning from the healthcare perspective to a non-healthcare perspective, with regards to the federal and state overlay, when it comes to operating a legal cannabis related business in a state where it is legal to sell, cultivate, transport recreational cannabis, Alex, what are some of the obstacles that these businesses face from a banking investment perspective, and why?
Sure. And the conversation I always have with any of my clients who are seeking to invest in this space is always, the scared straight portion of the discussion up front, where I tell them all the horrible things that the federal government can theoretically do to you. And then we discuss sort of exactly what you said, which was the risk tolerance. Banking is very much intertwined with federal law, as are other sort of, areas like taxation and immigration and sort of everything where you have a three-letter acronym agency being in charge. you're dealing with the federal government. And for investors, I sort of have developed some checklists that I go through, and everything from what is your immigration status, right? Are you a natural born U.S. citizen? Are you a green card holder? Are you a foreign investor? Because anything to do with immigration, you're dealing with customs and immigration, and they've been pretty clear that as long as it remains federally illegal, those are grounds to deny either an adjustment of status or maybe even facing a lifetime ban. So risk tolerances have to implicate that, and that really depends on sort of your source of income. And I can never advise them not to be honest with the government. Like, why are you coming? Why are you even coming to an investment? I've had lawyer friends being stopped at the border. They were ultimately allowed to enter, but what kind of conference are you going to? Is this like a medical cannabis or recreational cannabis conference? Taking a step back, banking is also very much regulated. So you talked about for simplicity, I'll call it a Rohrabacher amendment and what it does for medical. Recreational has traditionally had very much less of a protection. There is no congressional rider precluding you from being prosecuted. All of the protection had to do was with the Cole Memorandum. So that's a sort of a term people in the industry know. That was guidance by the Department of Justice to its AUSAs about how to use their prosecutorial discretion. It was never binding, but it outlined sort of a list of issues they should consider about, as to whether to prosecute somebody. And that had to do with transportation across state lines, how strictly they're complying with either the medical or the recreational laws in the states, and how robust those laws are. Is any money getting diverted to cartels? Are you selling it to children? Are you growing cannabis on federal lands? So once you went through that checklist, they would sort of decide, whether or not to prosecute you. That was issued during the Obama administration. Shortly thereafter, it was actually incorporated by reference into the guidance that FinCEN, which is the Department of the Treasury's anti-money laundering arm, uses. That remains on the books today. The Cole Memo itself actually has got withdrawn by Attorney General Sessions when he was an Attorney General for about 6 months. And he was not a proponent of cannabis, and he withdrew that guidance and said it goes back to the discretion of the AUSAs. Nobody seems to have noticed. Nobody seems to have cared. It doesn't appear that anyone changed the way they're doing it. I think the approach is, as sort of was explained by the New Jersey Supreme Court not too long ago in their discussion of whether you're allowed to reimburse for insurance, is de facto, it seems like the federal government is not enforcing. Like they've realized that the horse has left the barn, and you're sort of have to deal with the facts on the ground. That being said, there are no protections for recreational, so you really are dealing with risk tolerance. And that permeates everything from banking, where you have monitoring fees that increase the closer you get to the plant. So banks have come up with sort of tiers. You have plant touching, where it's sort of very limited, very regulated, and very expensive. Then you have sort of the second tier, which I like to think of like the picks and shovels, the people who provide the lamps, the landlords, not people actually, not licensees, but people who are very close to it. And then you sort of have tier 3, which is where all of us sit, which are, the accountants, the lawyers, the people who, provide services. And it's important sort of for the banks to know who they're dealing with. Banks hate finding out they're banking somebody in cannabis without agreeing to do so up front. So those are issues that sort of always have to be dealt with. Those are also the same tiers that investors look at. And look, you're able to invest in Canadian publicly traded companies that are listed on the U.S. Stock Exchange. So while if we were to put on our law school hats and be in a law school exam, and are those investors violating U.S. law? Well, NASDAQ seems to have said no, but it's a theoretical, supporting cannabis business, and then you get into all those issues. Does it apply across, outside of the United States? Then you sort of get to, all right, you're investing in a business that is cannabis adjacent, and that issue came up with sort of PPP loans, which excluded businesses. All of those issues are sort of considerations of, are you theoretically putting something on the board that you might have to deal with later on? And the closer you get to the plant, the more danger sort of increases. I will say that while there have been no prosecutions, it would not be accurate to say that the government is sitting on its hands. The Weed Maps subpoena out in California was issued. It was very broad. It actually went to both, licensed and unlicensed dispensaries. That had a lot to do with basically Weed Maps thumbing their nose at the regulator and saying, we don't care, when they said, don't list unlicensed dispensaries. You never know what the federal government does with all that information they collect, but they are collecting information. So they are keeping an eye out. Coloring within the lines is still the best advice. I think as lawyers, the most we can do, and ethically, is to advise an investor or a doctor or anyone else about, look, it's very easy for me to tell you what a federal law is. It's illegal, and I can't really give you much more advice on that, but I can help you comply with state laws and regulations. And that's sort of where we sit, and that's the discussion we have with investors or doctors or operators.
Well, thank you very much. I mean, I think that this has all been really helpful. We are at the end of the time for this podcast. So as just a last note, I just wanted to, again, show and have the audience understand why it's so important that anyone that's involved in any type of law may certainly fall into this cannabis industry at some point. Some of the key words that we've heard between both Richard and Alex are that it's, not only physicians and hospitals and licensed care, licensed long-term care facilities, ambulatory surgery facilities. We have landlords that are holding on to real estate. We have bankers, we have investors, we have other types of ancillary services that are being created in this industry, which is the cannabis industry. And so it's at this point that we think it's imperative that any type of attorney at least understand the fundamental and practical considerations, both legal, operational, for advising any client that you believe is going to get involved in this space, whether it's from holding a license within your state, within the medicinal cannabis program, the recreational cannabis program, whether it's any other type of healthcare entity that you represent. We hope that at least the considerations we've discussed today will provide you with some practical guidance that you can provide to your clients. And so with that, we also want to provide you with a little information about a publication that AHLA just published last summer. It's called the Healthcare and the Business of Cannabis, Legal Questions and Answers, because simply right now it's a moving target, this cannabis law, this cannabis industry. As we've heard from both Richard and Alex, there's a lot of, these are the concerns, this is the federal law, but what can we do in order to play in this game, but while also complying with the state and local laws. And if you have anyone that's interested in getting involved, certainly I would suggest and recommend looking out for that book, that publication from AHLA. I was the editor-in-chief with a colleague of mine, Jenny Nelson-Carney, and Alex and Richard were both authors within that book. So again, we're happy to have all been here. Richard and Alex, thank you so much for joining me. Have a great day.